we'll be identifying where things can go wrong. So let's start off. Are you all able to see my slides?
Yes, sir.
Yeah. So the first question that comes to our mind, is there a need to know about law for aesthetic dermatology? In my opinion and the experience that I have over the years, I have always felt that aesthetic dermatologists are at a low risk for litigation. But however low the risk may be, there is definitely a risk. There have been cases. Many of these cases do not end in litigation. They may start off with a dissatisfaction, and then either there is a out of court settlement, or if you do a good counseling, many a times it doesn't go further. We have to remember that the risk to an accident is always low when all safety precautions are taken. Similarly, the risk of litigation is always lesser or reduced when precautions are taken. If you all remember, for years together, the litigation against dermatologists was practically nil. Then came one case which was a landmark judgment and which actually demolished the view that doctors are immune from litigation for medical negligence. Therefore, we need to be on our safeguard, though the risk for litigation is low. And as we go through, navigate through this presentation and the subsequent presentations, we'll realize that it's not difficult to safeguard ourselves from litigation. So this was a case, it is said experience is the best teacher, but the fees are too high. So we should always learn from the adverse experiences of others rather than we facing them ourselves. We have to get the learning points, and the idea is not to stigmatize any dermatologist. Therefore, deliberately and consciously, I have withheld the names of the concerned dermatologists. We have to only learn what went wrong and how we can prevent that. So this was a case where a dermatologist was approached for permanent removal of unwanted hair on the patient's face and neck. Initially, the fluency of 40 joules was
Excuse
prescribed
me,
for the
sir.
first.
Excuse
Yes,
me, sir. Sir,
yeah.
actually, sir, are you running the slides? Sir, actually, the first slide is only showing here. So if
Oh,
you're run,
yeah, I am running the slides. Uh, should I try it again?
yes, sir. So just write one sir.
Now?
Sir, it's the first slide. So just move on to the next slide.
Actually, I'm moving it. I don't know why that's. Is this visible?
Yes, sir. This is, yes, now it's
Uh,
visible.
I'll go ahead with this because the full screen, I don't know.
Okay, okay, fine, sir. So this is visible.
Okay. So, this was a patient who went to the dermatologist for permanent removal of unwanted hair on her face and neck, and 40 joules was the fluency which was prescribed. As the patient was not responding, the fluency was increased to 45, and later on a subsequent visit to 50 joules. The allegations of the patient was that there was disfigurement of the face following the laser therapy. Secondly, that the laser therapy was not given in a hospital setting. Now, see the nature of the allegation. The patient has gone for laser therapy, hair reduction, and she knew beforehand that this is not going to be a hospital setting. And then the wisdom increases at a later stage, saying that the laser therapy was not in a hospital setting. Further, the procedure was performed by a nurse and not by the dermatologist. These were the allegations. The defense of the dermatologist was that it was contended that many laser therapies are simple to use, and a nurse or a non-physician operator can also be allowed to perform, provided there is proper training of that person. Now, they also gave an instance in California that only nurses and doctors can perform laser therapy, whereas there are no guidelines, state regulations in New York. So, it is not the case that laser therapy should be done only by dermatologists. Uh, Secondly, it is known that laser therapy itself has a lot of post procedure complications, which may not happen in any everyone, but it can happen. And these complications, such as pain, discomfort, hypo or hyperpigmentation, all these were brought to the notice of the complainant prior to the procedure. So there was a counseling process, there was an informed consent, and all these complications were mentioned. The patient consented to the procedure after this counseling procedure and giving the consent. She was also advised to use sunscreen photoprotective measures, but she had failed to do so. So the court said that laser therapy agreed with the defense, saying that laser treatment is an office procedure and it does not require a hospital setup. Going through the standard textbooks on that subject, the court also said that the fluency of 50 joules cannot be said that cannot it's not a standard protocol, and that the scar was due to that reason. Courts generally rely on expert evidence. They don't have medical knowledge. So the courts rely on experts to see whether that particular fluency was responsible for the scar or the hyperpigmentation. But they referred to a standard textbook on laser therapy, and they said that you can give a fluency of 10 to 100 joules. So 50 joules was held not to be something excessive. Based on this, the court held that there was no negligence on the part of the doctor. Before we take home a message from this case law, I would like to give a caution, word of caution, that this was a judgment given by a state commission. Now, in the hierarchy of the consumer courts, you have district commission at the lowest level, then you have state commission and the national commission. The decisions of the state commission are binding only on the commission in that particular state only. So we cannot say this is the law laid down by the consumer court, because that is not binding on the other courts. If it is by the National Commission, it is binding on all consumer courts. If it is by Supreme Court, it is binding on all courts. This is just to familiarize you about what cases happen and what is the defenses taken. The very fact that the laser was operated on the instructions of the dermatologist. So there was a supervision by the dermatologist. The nurse had not done it independently, and therefore the court was of the opinion that there was no deficiency in rendering service. As I said, expert evidence is something that the courts tend to rely on, and there was no such opinion to say that there was something wrong on the part of the uh, dermatologist. So we start off by saying that what we are navigating through today in this presentation is risk identification. So what is this risk? Risk is chance of something happening which will have an impact on your achievement. Every organization has some objectives to make this kind of profits, this kind of addition to the already infrastructure you have. So if at all there is a litigation, this will impact your progress or growth or development to a certain extent. You have some objective, the risk to litigation will obstruct this kind of progress. So each one of us, whether we are in solo practice, we have chains of cosmetic aesthetic dermatology clinics, or it's just one center, we all need to have a risk management policy in place, where the first thing that we do in risk management is identify what risk we are exposed to. Then the second thing is assessing the impact that may be caused because of this failure to redress that particular thing. And third is risk management. How are you going to manage these possible risks? Will you be able to prevent it? If it is not preventable, like supposing a claim comes, then having a professional indemnity will help you to at least reduce the financial impact. So that is called as risk management. So what is the purpose of risk management? It is to reduce the probability that risk to litigation will happen. If you cannot, it's also possible to eliminate it completely. Many times it's not possible. You can at least reduce it. You can control the loss that will happen. Loss, we are talking about the financial loss. So the impact, if it's going to be 20 lakhs, maybe you can reduce it to 5 lakhs, 2 lakhs, or maybe even zero. So a claim that would arise from a risk to litigation is to be managed. Then how are you going to finance this risk? How are you going to arrange for the lawyer? How are you going to arrange for the compensation, if at all that is payable, will be part of risk management. As we go further in other sessions that we propose to have in future, we'll be talking in detail about all this. So what are the different risks that one is exposed to in aesthetic dermatology? First and foremost is a unrealistic expectation. Second is informed consent issues, negligence, and very importantly, advertising and marketing pitfalls. Whether the kind of advertisement that you do falls on the wrong side of law, whether it makes us prone for professional misconduct before the medical councils, are the issues that can occur in aesthetic dermatology. So let's start with the first one about the expectation. So what are the patients expecting from us is a natural looking result, a minimally invasive procedure, or something which is non-invasive. They are looking for long lasting results so that you don't have to keep coming again. There should not be frequent maintenance or touch up procedures, and the downtime is very minimal. There should be low risk of adverse effect. So these are something very idealistic. These are the expectations of the patient. But what is important is that we have to tell the patient that none of these procedures, even if they are carried out by properly trained providers, by even dermatologists, they are not without risk. All of these procedures have some kind of risk, and whether they are comfortable with the degree of risk that may come. Like you are coming for, say, melasma, and a possibility of a post inflammatory hyperpigmentation following use of a chemical peel is a risk, and the patient should be able to undergo that risk or undertake that risk. Only then the procedure can be done. Many times patients have heard of miracle treatments, and but it may suit some type of skin or some kind of patients, but all procedures are not appropriate for every patient. This is what we need to tell the patient as part of our counseling process. As per one study, every type of skin, like treating Asian patients, require different consideration from that of other type of skins, because it is important to understand the unique characteristics of Asian skin, such as thicker dermis, higher sebocyte activities, and increased melanin content, which makes the Asian skin more prone to post inflammatory hyperpigmentation. And this is the reason why it is crucial for selecting appropriate treatments and products for our patients. While discussing about realistic expectation, however, realistic expectations you give to the patient, explain, have a counseling session, a detailed counseling session, the patient agrees to all the risks that are associated with the procedure. We cannot forget that there is a condition called as body dysmorphic disorder. So this is a disorder where the patient who is presenting to us has an intense preoccupation with a defect in appearance which is more imagined than being real. And it occurs in around 1% of the general population, and it's more prevalent in people who are seeking cosmetic surgery. So, all of us and a lot of people do get anxious, they get preoccupied, but the difference between BDD and a normal person who is anxious is that the individual's preoccupation is markedly excessive. So markedly excessive that it would cause significant distress and or functional impairment. So we can't label everybody as BDD, but review of literature has shown that the prevalence rate of body dysmorphic disorder is anywhere between 7 to 15. Another study has shown 7%. Yet another study has shown 6.3%. But the prevalence, this is about overt BDD, but subclinical or sub-threshold BDD occurs in a higher percentage, that is 18.4. So when it is a clear overt case of BDD, maybe it's very easy for us dermatologists to identify. But when it's subclinical or subthreshold, we may have some difficulty in identifying these patients. And there are, type of questionnaires and tools to do that, which we would be discussing in our later sessions. So it's important for us to identify such patients because they may not be a good selection of patient, because whatever you do, there is a risk that the patient would blame you for not giving you the right kind of treatment. Also, they also tend not only to have body dysmorphic disorder, but they can have comorbid disorders like major depression, social phobia, and obsessive compulsive disorders. So because of this, though your the expectations of the patient may be quite different from what a otherwise normal patient who presents for aesthetic dermatological procedures would have. So this was about the unrealistic expectation. Many a time, the patient in such cases would possibly go to a court of law seeking compensation. So it's a civil kind of negligence where the patient suffers some loss or injury, or in some cases, unfortunately, death also has happened following certain procedural treatments. In such cases, compensation is what is sought in a case of civil matter. Also, certain types of legal pitfalls can happen uh, because it is a violation of a medical council rules and regulations. We have a code of medical ethics, and there can be issues if we uh, violate those, and we can be uh, uh, there can be cases against us for professional misconduct. Now, one of the issues is we tend to employ a lot of unqualified persons. Now, as per the Code of Medical Ethics, we should not be issuing certificates of efficiency in modern medicine to unqualified or non-medical persons. But there is a note which says you can, but it should be there has to be proper training and instruction, and they need to be either surgical attendants, skilled mechanical and technical assistants, or therapy assistants. The treatment given by these set of people have to be under the personal supervision of physician. So there is a concept called as vicarious liability. So in case uh, this the code of medical ethics was replaced by another code which came in last year 2023, and those rules and regulations have been kept on hold nearly for so many months, and there is a chance that it may come back again or it may remain as such. All the same, let us stand familiarize ourselves with what are those provisions. It's similar to the provision that we just saw, and it says that you may train these people, but and if you employ such assistants in your practice, the whole onus or the burden of any liability arising is on the RMP. RMP is a registered medical practitioner. This is the term used in the Code of Medical Ethics. So we may train someone as therapy assistants, but the vicarious liability is entirely on the dermatologist who is employing and training them. Similarly, uh, if you are giving them training, it's you can give them certificates, but you should be only asking them to do it under supervision of dermatologists, and the certificate should not be that training in aesthetic dermatology, because the tendency to use this certificate to set up their own practice independently is very high. So it's best that this training is given only for in-house use, and the certificate should mention about experience, skills, and competency obtained, the duration of training, and kind of work done. Whether this data or that skills that have been developed is true or not will entirely lie with the dermatologist. So, further, we tend to, many times call ourselves as aesthetic dermatologist or something of that sort, uh, or a cosmetic surgeon and things like that. As per the Code of Medical Ethics, or it's also called as Indian Medical Council Professional Conduct, Etiquettes, and Ethics Regulations 2002. As per one of the clauses, a physician shall not claim to be a specialist unless he has a special qualification in that branch. So there is no qualification as such in aesthetic dermatology, which is a recognized qualification, or a NMC recognized or a state medical recognized qualification. So this, when the new thing came, they specified this, that RMP shall not claim to be a clinical specialist unless he or she has NMC recognized training and qualification in that specific branch or modern medicine. So the position of law is similar now. There is no change. Only thing, they have specified that it should be a recognized training. That means it should be in the list of recognized courses or degrees or fellowships by the NMC. Only then you can claim to be a specialist. So how do I declare that I'm an aesthetic dermatologist? Maybe you write your qualifications, your MD, DVD, or even DNB dermatology, and below you can write special interest in aesthetic dermatology, because you want to draw the attention of the patient You cannot draw your, by saying that you are because a lot of physicians also write, I'm a diabetologist. But unless you have a DM endocrinology, you cannot call yourself to be an endocrinologist. The next important thing that comes in the field of aesthetic dermatology is about advertising. So, a lot of advertisements are being displayed with impunity in different social media and others. So a lot of patients, a lot of dermatologists ask this question that when someone else is doing, why I cannot do it? The the answer is that maybe they have not yet got caught, but somebody can be caught at some point of time. There are certain medical councils who are very proactive, and there can be disciplinary proceedings if at all there is violation of this section 7.11. What does this section say? That you can contribute to the lay press articles. You can give interviews regarding diseases and treatment, but it should not be in the form that you are advertising yourself or you are soliciting practices. So what does this mean? uh, Supposing you say that you are doing something on fat grafting, so you give a overview of what fat grafting is all about, and at the end of it, if you are interested in this particular procedure, you may contact Dr. So and so on this number and this address. So till the time that, as this is very clearly written, that it is open to write lay press under his own name. You can write your name, you can deliver public lectures, give talks on the TV, radio, internet, and even send announcement of the same to press. But you cannot say that come to me for treatment for this. There are a lot of controversies and debates on this issue, but as the law or the regulations stand as of today, is what I am saying. So, a lot of people get angry with Dr. Subodh Shirur saying that how is this possible? Is this right or this is wrong? This is not a law made by me. This is a law, the Code of Medical Ethics is incorporated in the relevant statute in the Act, and that can be applied even if it is not applied to a certain set of doctors who have probably escaped it so far. So it is not only the new code of medical ethics which I said that is on hold, but it can come up at any point of time. It is not only to a RMP, but even if it's that RMP is part of an organization, association, society, he also cannot give approval of some products or software platforms or approvals or recommendation of certain drug brands. So something of the nature of advertising is what even you being part of an association or organization are not permitted to do so. You cannot boast of cases. You may possibly publish case reports saying that this was a response, this response was miraculous or something different from the routine. All that can be done, but putting this in the newspapers and boasting is what is not allowed as per the code of medical ethics. One more thing is about making announcement. We just discussed that you cannot advertise, you cannot make announcements in the media, and you can do it only to the extent of having health sessions or public talks, which are for general health of the patient. But you can make announcement in the media when you start practice, or you are going to change your practice, you are changing your address, or if you are going to be on temporarily be out of station, say for a month or three, you go abroad for some training, you can make these announcements in the media. It can be newspapers, electronic media, or social media. Once you come back also on resumption of practice, you can again make this. If you are giving away your practice, you want to retire or you want to give away your practice to someone else since you're going abroad or something else, then on succeeding to another practice, you can make a announcement. You can also make a public declaration of charges. So that is optional. You are bound to make these uh, display of fees as per the Clinical Establishment Act, which is applicable in some states. So the institution also cannot make these announcements. It's earlier, the code of medical ethics as it stands today applies only to RMP, but the new code of medical ethics, whenever it becomes applicable, it prohibits even corporate hospitals or owners of nursing homes to make such announcements which will solicit patients. So So this was about medical counsels or professional misconduct. We saw about possibility of a civil liability. Uh, the most dreaded thing is a criminal liability. Nobody wants to go behind bars for whatever treatment you have done. There have been instances where procedures such as hair transplants have gone wrong. A patient aged about 35 years died during the process of hair transplantation undertaken at a hair studio in Delhi. The patient returned back home on taking the treatment, but he suffered serious pain over his scalp. There was swelling of the face and shoulders, and he had to be admitted to Escorts Health Institute and Research Center, where he was diagnosed to be having Stevens-Johnson syndrome. He developed septic shock and multi-organ failure. The patient died, and his brother went pillar to post to file a complaint. The complaint was filed, but nothing happened further. So the police did not take any action despite filing a complaint. So a writ petition was filed. So this is one of the other areas where a patient can file a complaint. We saw consumer court, we saw a medical council, and third is a criminal court, or even before the high courts or the Supreme Court. High Court, by filing a writ petition under Article 226 of the Constitution of India, and a writ petition before the Supreme Court lies under Article 32 of the Constitution. So this writ petition was filed saying that this investigation should be handed over to the CBI or any other independent agency. Amount of 30,000 was stated to have been received for this hair transplantation. So what was observed by, what actually happened was this was not done by a dermatologist, not even under the supervision of a dermatologist, but this was done uh, by technicians. So the observations of the High Court, the Delhi High Court, where the writ petition was filed, the High Court said that it being aesthetic surgery, it needs to be performed only by qualified dermatologists or trained surgeons, and informed consent of the patient is necessary. Now, the practice of carrying this out in salons with the aid of technicians is a matter of great concern, because the persons who are doing it are neither skilled nor qualified to undertake to do such procedures or to handle any complications when this is done. So, it very clearly said that it should not be done except under supervision of a trade surgeon or a dermatologist. So it gave directions to the government of India as well as to the government of Delhi, saying that some steps needs to be taken, because so far there are very scanty provisions of law to tackle this kind of quackery or procedures being done by unqualified people. So the court said that, you should be having some regulations in place, especially for aesthetic surgical procedures and hair transplant. So in September 2022, nearly a few months after this Delhi High Court judgment came the first guidelines on aesthetic surgery and hair transplant procedure. This was issued by the National Medical Commission, the Ethics and Medical Registration Board, dated 20th September 2022. So these guidelines talked about who can do the procedure, especially preferably dermatologists or plastic surgeon who have the training in that particular procedure. Secondly, it also said what are the requirements of such a clinic. It can be a daycare clinic, or it can be a full-fledged hospital where the procedure can be done, but all emergency resuscitative measures should be present. Ambu bag, all this should be present in the clinic to tackle any complication. They have also talked about a standby anesthesiologist in the nursing home or the clinic where it is performed. Where it's a daycare center, they have also given as part of guidelines that you should be having an affiliation or an arrangement with uh, a center which can provide with intensive care or emergency care if at all is required for the patient. So this is one of the few guidelines on aesthetic surgery and hair transplant procedure. So any violation of these guidelines could land us into legal pitfalls. It is not only non-qualified persons, but also a dermatologist was facing the heat for performing a hair transplant where the patient died. So this case happened in Mumbai. A 43-year-old businessman insisted that the dermatologist does the hair transplantation of 9250 hair grafts in one sitting. He was a very busy person and he did not want to have too many sittings. So he asked him to do all the hair grafts in one sitting. So the procedure started at 2:30 p.m. and continued until 2 a.m. So so many hours it went on, and it was to progress further. So the dermatologist had grafted around 3,700 follicular units when the patient felt severe pain in the nape of his neck in the clinic itself. The dermatologist discontinued the procedure, and he was given some treatment at a local hospital, and then he was asked to go home. His problems continued. He was taken to three different hospitals, and eventually the patient died. So the key point that we have to take from this case is the expectation. The expectation of the patient was that I want to do everything in one sitting. I don't have time for that. We should remember that we are the qualified persons. We should decide how many grafts can be done in a one particular sitting, and we should not succumb to the demands of the patient. This matter is still ongoing, so I would not say much about the case, but we have to remember that the patient should be advised that when you want certain treatment, it can be in phases, and then you should be ready to come in those different stages for the procedure. Very importantly, we doctors are not guarantors of good results. The results may happen, may not happen. This is a point we have to make not only as part of our counseling, but as part of our informed consent. The sometimes patients come saying, my brother got good results, my friend got good results, and I expect the same. As we discussed a little bit earlier, things may be best for the patient's friend, but it may not be the same outcome that can happen in every patient. So it can change from patient to patient. There can be variation. Somebody may get complications, though it is not expected at all. So this was a foreign case, not an Indian case. This was a tattoo removal procedure. The doctor said that, do not worry, it's a simple procedure, but the patient developed unsightly scars. Definitely, the dermatologist had asked for history of keloidal tendency and scar formation, and he has said that he doesn't have that. So, despite getting this unsightly scar, so a complication of a procedure is not an indication that there is negligence, because these complications can happen in the best of hands, and it's not because of negligence, but because the procedure has inherent risk which cannot be attributed to the skills of the doctor. So the court found in favor of the physician and held that the doctor is not a guarantor of good results, and therefore the complaint was dismissed. Next very important point is, a lot of time legal notices come. This is one good thing, managing of legal pitfalls is very, very important at every stage. If the patient is dissatisfied and he screams, shouts in your clinic, try and counsel him and explain that you have already, as part of the counseling process, told you about the need for photoprotective measures. You have not been able to take it, and therefore this has happened. Over a period of time, this pigmentation will go off, and this is what you need to do. Similarly, when a patient sends a legal notice for compensation or for some deficiency of service that one has done, do not ignore it, because failure to respond is a chance lost. And also, do not reply impulsively, because what there is no prescribed period for responding to a legal notice. You may take 15 days, 20 days, but think over what that case is all about. Build up the best defense and then reply. Take professional help if it's required, but do not reply impulsively, because when you get very agitated because you've done everything for the patient and still the patient has acted smart to you, with you, for sending you this legal notice, and then you replied, go do whatever you want, I have done the best. And these statements which are made impulsively sometimes can be to your detriment when this matter finally comes to a court of law. Lastly, a notice from a consumer court. We should not ignore a notice from a consumer court, for that matter, from any court, because a notice from a court is not without teeth. These consumer commission are not without any teeth. They have teeth which can go very deep. If you do not appear before these consumer fora, the decisions may be taken ex parte, which means the decision will be taken in your absence without your defense. And once the decision is taken ex parte, you don't comply with the order made by the court, there can be a possible arrest. And if you do not make the payment, there can be even, I'm not trying to scare you, but we should know what the law is so that we do not go to that level where we are totally blissfully unaware that something strong action is being taken against us. So, if there is any property and compensation has been awarded by the court, then this property can be attached, sold, and the proceeds of those property can be given as compensation to the person who, in favor of whom the award has been given. So do not neglect a notice from a consumer commission and take appropriate professional help. It is a prudent thing or a good thing to sensitize your reception staff about this, because many times a legal notice comes, it just keeps lying there, your reception is very very busy, and no attention is given to that, or you take a vacation and the notice comes during the vacation, and then suddenly you get a order from the court because your staff has forgotten to inform you about this notice from the court or a legal notice, because the repercussions, the implications of not complying with the order, not appearing in the court, I have already mentioned to you. So if these things needs to be avoided, make sure that your reception uh, is sensitized to this issue. They should be able to perceive notices that are coming, because the name of the court from which the notice has come is written on the envelope. It's a good practice when the inward, when the notices are taken, to write the date and the time as acknowledgement when this was received. Because many times the notices are dated, say, 1st of April, and you receive it on 1st of May, by which time your time to file a reply is lost. You get 30 days from the date of receiving the notice to file a reply. And the courts have the discretion to give you further 15 days. But for that, you need to go to the court to get further time. So, in view of this, do not ignore, sensitize your staff for any possible such letters. So, all this risk management is like a shock absorber. We have a shock absorber in our vehicles, which is a mechanical device which controls the movement of a vehicle's suspension system. It plays a crucial role in dampening and absorbing the shocks and vibration generated by the uneven surfaces of the road. So, like the shock absorber, which enhances ride comfort, stability, and ensures better handling of the vehicle, similarly, risk management is like a shock absorber. It will minimize the risk to litigation, because risk to litigation cannot be eliminated. You may do everything that is required, but many times, despite doing everything right, some patient may be dissatisfied and may drag you into litigation. So risk management reduces the risk, uh, not entirely, but it definitely reduces the impact of litigation and helps you to better handle the litigation if at all it occurs. Better handling, like you have a consent form which mentions all the complications, and the patient develops one of these complications. You can always say, see, we have mentioned you that the risk to developing hyperpigmentation was already mentioned, and therefore your handling of the litigation becomes much better. So with this, I come to an end of this session. Uh, Looking forward to many more sessions in the future, where we'll take different issues on informed consent, maintenance of medical records, many other case laws, and case scenarios, how we'll handle different things. I will also invite the delegates, if they have any specific issues that need to be discussed from a legal aspect, we can take those topics as one of the sessions. Now I open this session for question and answers. If there are any, please feel free to ask me questions. There is one question that has been asked. Do we need to have a disclaimer in our website saying that this is not advertising? So, advertisement, like you see newspapers, they will write, this is an advertisement. A disclaimer saying that this is not an advertisement may not work. If the nature of the disclaimer, the nature of the contents is of a advertisement. We just saw some time ago that when is it called advertisement? When the contents will uh, have an effect of you soliciting a patient. When you say that I am practicing in this area, this is my mobile number, I do fat grafting, I do chemical peels, I have done so many procedures without any complications, the effect is of advertisement. Whether your intention is of advertisement or not is uh, not valid. Secondly, let's remember one thing, you cannot contract out of a law. If a law says something uh, that you have to follow this kind of like advertisement is not allowed, is the rule or regulation. You cannot say that I permit myself to be given the advertisement. So you cannot even contract out of a law. So a disclaimer may not work. The contents of your material that you put up in social media or the print media will determine whether it amounts to advertisements or not. I hope I have answered that question. Uh, Dr. Archana has asked this question. Can the prescription sheets have the cosmetic procedures done at the clinic? I'm not sure what this question really means. Are you, Dr. Archana, is there a possibility of Dr. Archana unmuting herself and asking this or clarifying this?
Yes, sir. Sir,
Yeah,
I'm just doing that. Allowing her
yeah.
to do.
There's,
Hello, sir.
yeah.
It's just that on the side, whenever we write a prescription in a patient for the prescription, whenever we write, is it allowed to write the procedures that we do at the clinic on the side? If you can print it and give it to the patient, is what is my question.
Yeah, there is no harm in doing that because you are
Yeah.
not doing that for public at large.
Hmm.
What we
Hmm.
have talked about is social media, in the
Okay, sir.
newspapers, magazines, right?
Yes.
You already have a contract with your patient. You already
Yes.
have some relationship patient,
Hmm.
so
Hmm.
that the patient has to know what are the different kind of procedures you can do.
Procedures available. That
There's
is
no
legal.
harm with
And
doing that.
the files can also have the same as a print on them.
Yes, yes, yes.
Yes.
Okay.
Okay. Thank you, sir. Thank you.
Uh, there's a question by Dr. Sunita Thomas. Many a time, cosmetic clinics who do hair transplant employ a dermatologist on board who is not trained in hair transplant. Is the dermatologist held responsible if a complication occurs, even the dermatologist has not done the procedure? Absolutely, because as I said, that if somebody who is non-qualified, now obviously, if the dermatologist has not done the procedure, someone who is unqualified has done, because you're keeping the dermatologist on board just to show that he's the face or he's the one who is supervising the procedure. There are two things in this. One is the dermatologist himself is not trained in hair transplant, therefore, he is unable to supervise that procedure. Like, I may not be trained in Botox, so obviously, I cannot put my name as a person who is supervising therapists in that. So obviously, that is a violation here. So just giving your name to a uh, transplant center is not correct, because that person should be not only qualified but skilled to do that procedure or trained to do that procedure. The guidelines that we talked about, issued by the Ethics and Medical Registration Board, also talks that you have to have the training. It is not sufficient to say that you are MD dermatology. The second is point is the dermatologist held responsible if a complication happens? The one of the foremost question is, what is the training you have? I'll give you an example of a general surgeon who had put up a actual advertisement saying, I've done so many, some 300 or 400 laparoscopic surgeries, by the laparoscopic surgeries, and without complication. A lady teacher who went to him developed a bile duct injury. Now, bile duct injury is common after laparoscopic cholecystectomy, but it is more common in people who are untrained. It was shown that he had no training whatsoever. So his qualification as a MS surgeon is not sufficient to him to be called a trained person in laparoscopic surgery. Same way, simply because you are a dermatologist, I'm not trained in hair transplant, so I should not go to such a center where I'm expected to supervise someone simply to as a face rather than having the skills. So definitely the dermatologist will be liable, and there is, I also discussed about vicarious liability. So there can be vicarious liability also if complication happens and negligence is proved. What is important is that the procedure was done negligently can also be has to be proved. I hope I have answered that question, Dr. Sunita. Uh, if it is done by a trained hair transplant surgeon, will the dermatologist be held responsible? So, why would there be a dermatologist if you already have a trained hair transplant surgeon who is qualified? You don't need a dermatologist. As per those guidelines, a trained surgeon or a plastic surgeon can do the surgery. I see no reason why a dermatologist should be the face where you already have a trained hair transplant surgeon. There's another question about, does showing patient results on the internet or website amount to advertising? If it is in the nature of a public health talk or creating awareness, it does not. At the same time, let's remember that this can intrude into the privacy or the confidentiality of the patient. You have to take proper precautions so that the identity of the patient is not disclosed, and you have to also take the consent of the patient, so that many times, even if you have masked the eyes, there is a possibility that from the other feature the identity of the patient can be made out, especially the patient himself. If he sees it, and if he sees that it is being used for promotional activities, can uh, get dissatisfied and make a claim against you. uh, Thank you, Dr. Sunita.
Sir, I have a question. Am I
Yeah.
audible?
Yes, Dr. Deepali.
Yes. Sir, I have a question. So I have seen a lot of young dermatologists, like a lot of my juniors, who start putting social media posts, but it is in the name of their clinic. Um, so my question is, from my understanding, corporate hospitals or chains are allowed to advertise, but as individual doctors, we are not allowed to do that.
Yeah.
So, is it acceptable for people to advertise via their clinics, or can it still come back to you as having done something wrong?
As of today, the Code of Medical Ethics applies to RMP, or the Registered Medical Practitioner.
Okay.
As I showed you, the modified the new code of ethics that has come in August 2023, and within few days it was suspended. It's on hold. So at any stage of time that if at all it is revived, then corporate hospitals also will come under the purview of these code, because the code is essentially for doctors, right? So
Yes.
if you advertise in the name of the clinic,
Hmm.
then nobody is saying Dr. Subodh ke paas aao, right? It simply
Hmm.
says you come to the clinic. So you are not boasting, you are not advertising yourself. So to
Yeah.
that extent, the code of medical ethics did not dilate on that particular aspect. But in the same, and the new ones do talk about that. But
Okay.
I'm little, I'm wondering how will this really be taken by the courts. There were some medical councils who issue notices to the hospitals. There
Hmm.
are, and they have decided against them. But when it went to the high courts and all, saying that they have no jurisdiction, they have fallen short. So the same issue may come up further, because what are you doing as NMC? You are registering doctors. You are not registering pharmaceutical companies. You are not registering hospitals or nursing homes. Then do you actually have the jurisdiction? Where does the jurisdiction come from? Can be a issue. But the point is, the regulation is that it will not allow corporate hospitals and owners of nursing homes to use it even in their name. So as of today, it is relatively safe.
Okay, sir.
Yeah.
Thank you. So both the
Thank you.
website questions were also mine. Thank you.
Okay. Okay. Yeah.
Thank you.
Are there any further questions? I think we come to the end of the session. Pallavi?
Yes, sir. So we come to the end of the session. So there's a question from Dr. Uttam Lenka uh,
Okay.
in the chat
Okay.
section only.
Okay. Some doctors are posting patients' testimonial on social media. Is it ethical? Uh, I am not seeing any bar about this, because the patient himself is giving the testimonial. Only thing, whether the patient is aware that this testimonial will be put in social media, because again that would intrude into his confidentiality. If the patient is, say, a celebrity or whatever, or the patient simply doesn't want the world to know that he has undergone a certain procedure, so then there is a possibility that the patient can file a complaint against you for breach of confidentiality. So keeping that risk in mind, you can also take a consent from the patient, or you inform the patient that this testimonial will be used in the social media. The contents of that particular testimonial are also important, because you can fake it, you can fabricate it, you can build up a patient and say that I've got this excellent results and things like that. If those kind of testimonials are misleading, there can be issues even on that count.
So thanks Dr. Shubodh Shirur for such an enlightening talk. On behalf of Parsons Dharma and all the participants, I would like to express our sincere gratitude for this informative and engaging webinar on medico-legal aspects in aesthetic dermatology. Dr. Shirur, your expertise and insights on this crucial topic have been invaluable. You have shed light on complex legal issues in a clear and concise manner, providing us with practical guidance that you can directly apply in your practices. The audience participation throughout the session was truly commendable. The thoughtful questions and discussions highlighted the importance of this topic and the collective interest in navigating the legal landscape of aesthetic dermatology. We are grateful to each and every one of you who joined us today. Your active participation enriched the learning experience of everyone involved. This webinar has undoubtedly equipped us with the knowledge and tools to approach aesthetic dermatology procedures with greater confidence and clarity. Thank you once again to Dr. Shirur for your exceptional presentation and to all the attendees for your valuable participation. We look forward to attending more such informative events in the future. Thank you all.
Thank you so much. Thank you.
Yes, thank you, sir. Sir,
Yeah.
before just closing the session, there's the last question that we had received from Dr. Archana. Sir, if you can just address it.
Okay, 1 minute. Um, Instagram posts and status updates, are they allowed legally without the disclosure of the doctor's name? It depends on what the post is all about, what are the contents of the post, because the contents will say whether it is amounting to advertising or not. If there is no disclosure of the doctor's name, then what is the intention of the post also will matter. So the contents will determine whether it is advertising. And advertising is when you say that I am so and so, and this is where I can be available for treatment, something of that nature. This is my clinic, this is where I'm available, these are my qualifications, these are my fellowships. All this is can amount to advertising. I hope I have that answered that question, Dr. Archana. Okay then, Pallavi,
Yes, sir. Sir, thank you.
any more
Thank you very
questions?
much,
Yeah,
sir. Yes, sir.
yeah,
So we don't have any more questions. So thank
yeah.
you very much, sir. Sir, we will be sharing your contact details with all the doctors. So if they have any other further clarifications, they'll just be directly in touch with you. Thank you.
Okay,
Thank you very much. Thank you to doctors and everyone.
yeah, bye.